Hello friends, today I'll be discussing about sources of international law. First, I'll go forward with the introduction, then sources of international law, and then I'll be concluding my lecture. So, before we go forward with the sources of international law, let us understand what is international law. International law is the body of rules and regulations which the countries agree to follow in their regular discourse with each other. In simple terms, international law deals with the relationship between sovereign states and other international law subjects. Why is there a need to study the various sources of international law? The first reason is that these sources are legally binding upon the states and the other subjects of international law. And the second reason is that these sources bring in a sort of consistency and legitimacy in the way geopolitics happen. The third reason is that these obligations are upon the states as well as upon the other subjects of international law. The objectives of this lecture is to understand the various sources of international law and see how these sources are being applied to resolving disputes among countries, and also to study the hierarchy and the status that each source holds in the ladder when it comes to sources of international law. Sources of international law have been divided into two sources: traditional sources and modern sources. Article 38 of Statute of International Court of Justice covers under its ambit four sources of international law: international custom, international conventions, general principles of law recognized by states, and the fourth one is judicial decisions and teachings of jurists. And it also recognizes ex aequo et bono, which means through equity and conscience. Let us understand international custom as a source of international law. So, how is the custom derived? It is derived from widespread similar state practices over a period of time. What is a state practice? It is nothing but an act or a statement by a state from which views about customary law can be inferred. It includes physical acts, declarations in abstracto, that is, general law or general assembly resolutions, and etc. There are various elements of customary law. The first one is antiquity. Let us suppose that there are two countries, Bharata and Lanka, and there is a small island which separates both the countries. The ships have to pass through this island. Lanka and Bharata mutually agree that when the ships pass through this island, none of them will attack or capture each other. This custom has been followed in antiquity. The second element of customary law is uniformity of state practice. Let us suppose that there are two countries, country A and country B. Country A and country B mutually agree that their diplomatic bags will never be looked into. The third element of customary law is consistency of state practice. In the example I gave regarding Bharata and Lanka, let us suppose that there is also another custom that each country has to salute the other country's national flag while passing through. The fourth element is opinio juris siva necessitatis. Let us suppose that there are two countries, country A and country B. Country A and country B both have been rescuing victims of shipwreck. Country A is doing it out of morality, and country B is doing because international law mandates it. The latter falls under the category of opinio juris siva necessitatis. An important case regarding international custom is the Anglo-Norwegian fisheries case, which introduced the state baseline method. So before I go forward with the case, let us understand the law of the seas. So the first is the international waters, then comes continental shelf, then it is the exclusive economic zone, then contiguous zone and territorial waters. So what all waters belong to a country? It is the territorial waters and contiguous zone. Above this, the exclusive economic zone, it will amount to 200 nautical miles. This is not part of a country. And then comes continental shelf, then comes international waters. So in this case, if you see the baseline, it was ruled that the way in which the baseline would be measured was through straight baseline method. But here, England objected because it put England at a disadvantage. Norwegian territory was filled with fjords. The International Court of Justice recognized the rule of state baseline method and held that because of how the coastline was in Norway, the state baseline method was the proper one. Let us understand international conventions as sources of international law. Under Article 38 of Statute of International Court of Justice, this has been given the topmost position. Conventions are nothing but agreements that are written and legally binding. These agreements give rise to rights obligations that both the parties must follow. The parties here are countries. Some of the examples for conventions are Geneva Convention of 1949, which deals with the treatment of victims of war, and Vienna Convention on Law of Treaties 1969, and Paris Convention 2015, which deals with climate change. Let us suppose that there are six students: Bhima, who comes from India, and Alexander, who comes from Greece, and Sangakkara, who comes from Sri Lanka, and Shaoli, who comes from China, and Ji-sung, who comes from South Korea, and Haruki Hiromoto, who comes from Japan. All these are studying in Nalanda University. The students mutually agree that when there is a class, no one will interrupt others and everyone will get equal speaking time if a question is asked, and the conflicts will be resolved through voting. All these rules will be made into a document and everyone will sign it and follow it. This becomes a classroom convention. This is how conventions are formalized and parties are made signatories to it. The third source of international law is general principles of law recognized by civilized states. The first one is the principles derived from municipal law. For an illustration, Jack Sparrow was caught for piracy by England. He was produced before court and convicted for piracy. In prison, he escapes and he is caught in the high seas again doing piracy. He pleads that he cannot be convicted for the same offense twice. This is nothing but double jeopardy. The second principle is the principle derived from specific nature of international community. Pacta sunt servanda meant agreements must be kept. Like how people are bound by Indian Contract Act, countries are bound by what they agree upon in the conventions and treaties. The third principle is the principle which is intrinsic to the idea of how law and basic legal systems function. Pablo Escobar was belonging to USA. He gets arrested on accounts of terrorism and drug cartelization, and without providing him a fair opportunity to be heard, the court convicts him. He pleads before the higher court that his right to opportunity to be heard and right to fair hearing is violated. The next is principles founded on nature of human beings, known as rational or social beings. Nelson Mandela, an African, was captured by English people and put to servitude. He pleads that servitude and slavery has been prohibited by the international community and the international law and escapes prison. Fourth source of international law is judicial decisions and writings of jurists. In North Sea continental shelf case, the rule of equidistant measuring of baseline was held to be at a disadvantage to Germany because Netherlands was concave baseline. In this case, the jurists had opined that for a custom to be called a custom, it should be a continuous practice and it should have been followed in antiquity and should have not been rejected by majority of the states. The rule of equidistant measuring of baseline was held to be inconsistent with the laws of custom. Second one is Gambia versus Myanmar. Here, Gambia brought a case against Myanmar for genocide, accusing them of committing genocide against Rohingya Muslims. In this case, Bosnia versus Serbia 2007 case was cited to understand and deal with interpretation regarding elements of genocide, and they held that genocide will include intent to destroy and states' responsibility for genocide. One person should have not caused the genocide, but the entire state should have been involved in the genocide. The fifth source of international law is equity. In North Continental Shelf case, it was held that equidistant measuring of baseline would put Germany at a disadvantage compared to Netherlands, as Netherlands' coastline was concave in nature. Let me illustrate regarding equity. Let us suppose that there are two children who want to eat cake. The first child says that he wants to cut from middle so that he gets the creamy part, and the second child gets the other part. Law of equity will state that the cutting of middle part would be disadvantageous to the second child, but cutting from top to bottom would make the shares just and proper. The other sources of international law are ex equo et bono, which is similar to equity and good conscience, and next, resolutions of General Assembly. The resolutions adopted by General Assembly are also sources of international law. Let us suppose that the General Assembly adopts a resolution stating that genocide or sacrilege should be avoided, and country A goes forward and picks up genocide with country B. Here, since the resolution was adopted by both country A and B, they have violated the resolution, and thus this matter will be elevated to the level of International Court of Justice. Next, unilateral acts of states. Let us suppose that Bharata was ruled by Shivaji Maharaj, and Lanka was ruled by Ravana. Shivaji Maharaj, out of love, states that I will give river Yangtze to Sri Lanka, and Sri Lanka accepts this as a gift. This is nothing but unilateral act. This has recognition under unilateral laws of international law. Next one is Memorandum of Understanding. Let us suppose that India wants to buy oil from Russia. In the Memorandum of Understanding, it is agreed that in exchange for oil, it would give diamonds to Russia. This law has to be adhered, and this memorandum of undertaking will become a source of international law. Thus, I would like to conclude by stating that sources of international law are of two types: primary sources and modern sources. International custom, international conventions, general principles of law, all these are primary sources. Judicial decisions, equity, then resolutions of General Assembly, unilateral acts, all these are modern sources. In the comments, do let me know what makes a custom an international custom and what is pacta sunt servanda. And can you briefly summarize what I had stated regarding North Sea continental shelf case, Gambia versus Myanmar, Bosnia versus Serbia, and Anglo Norwegian fisheries case? Thank you for listening to my lecture.